Today's presentation is based on corporate real estate. The case we are looking at is Alarms New Zealand Limited and 15 Hopeton Limited. The address where this case occurred is at 15 Hopeton Street in Freeman's Bay, Auckland City. The tenant is Alarms New Zealand Limited and the landlord is 15 Hopeton Limited. This presentation is presented by Emily, Ryan, Lachlan, and myself, Alexi. The tenant, Alarm New Zealand, had entered into a lease contract to lease out level 3 and 10 car park spaces at 15 Hopeton Street, Freeman's Bay, Auckland. This building is owned by the landlord at 15 Hopeton Limited. The lease of the car parks was valid for 10 years from the 21st of September 2012, with a renewal set in place for 5 years. Furthermore, the leased car parks were not specifically identified in the lease itself, and often there was a change in the allocation of car parks for the tenants. The landlord 15 Hopeton Limited had wanted to sell, transfer, or provide exclusive possession of the 4 accessory units of the building, which is known as titled development, including car parks 73 to 76 located under the building. Hopeton New Zealand, however, had agreed to transfer car parks 73 and 74 to the residential units. However, it had led to a concern or dispute by Alarms New Zealand Limited that even if there was an order to prevent car parks 73 and 74 being sold, they were afraid that car parks 75 to 76 would still be in risk of being sold.
The first issue related to Alarm New Zealand claiming that Hopetown misled them into moving out when it was not necessary to do so, resulting in a combination of costs and losses for the company. The underlying claims are for breach of lease and derogation from grant by breach of the covenant, for quiet enjoyment, trespass and misrepresentation under the Contractual Remedies Act. The second issue related to claims of breaches of the Fair Trading Act, bailment and conversion. Alarm New Zealand contended that it had been in discussions with Hopetown regarding the quantum and location of the car parks, and undertakings, while not documented, were given by Hopetown. While Alarm New Zealand assisted Hopetown during the structural works, during that time, unbeknown to Alarm New Zealand or the purchaser of the car parks were sold by Hopetown to a third party. Hopetown acted entirely in its own interests, with complete disregard to the previous use of and understanding of the car park locations. Unfortunately, Alarm New Zealand were not successful in this claim. The third issue related to Hopetown's Engineers Advising Council, that there were structural deficiencies in the building. It should be noted that these deficiencies were raised as a result of substantial structural work, adding floors, and possibly changing use from office to residential. Alarm New Zealand requested compensation for relocating to allow the structural works to occur. Compensation was rejected by Hopetown. However, Alarm New Zealand have made a claim and Hopetown have extended that claim to council should Alarm New Zealand be successful.
So in the outcome, Hopeton said that they would not have any objection to an interim order being granted for car park 75 to 76. They've also made it clear that they will have no intention to deal with these car parks other than in favour of Alarm New Zealand. Looking at the apparent of unavailability of any other car parks and bearing in mind of Hopeton's actions are to date, so actually an interim order was actually granted, but car park 73 to 74 was dismissed in this case. Also, in the usual courses, costs will be awarded now, but in this circumstances, in this case, the court has decided that the cost will be reserved pending on the outcome of another substantive hearing later on. And if they had any dispute, they should write back to them in memorandum of within 28 days of this decision.
The way a proactive property manager could have avoided the situation in the case study would have been to add more specific terms of lease for the accessories and the car parks for the lease, such as saying exactly which car parks would be allocated to Alarms NZ, and this would have avoided the situation where they were arguing over which car parks were to be included for Alarms NZ. And of course, Alarms NZ would have wanted to argue that they want all of their car parks to be right beside each other, because as a business it would be quite ineffective to have customer or staff car parking scattered all around the property. And also it would have been effective to have clauses for procedures if some car parks became unavailable for whatever reason, whether that have been renovations or seismic strengthening or otherwise. And also a proactive property manager could have put in some more work into double checking correspondence between Hopeton and Alarms NZ, because as we've seen in some parts of the case, such as paragraph 67, there were incorrect correspondence between the two parties, and this added a lot of unnecessary complexity to the case. And this could have been avoided simply by the property manager double checking that everything that is being bounced back and forth is actually factual and correct.
The plaintiff, Alarm New Zealand, leased a level 3 and 10 car park spaces at 15 Hopeton Street, Freeman's Bay, Auckland, a building that is owned by the defendant, 15 Hopeton Limited. Alarm New Zealand applies for an order against 15 Hopeton Limited to stop Hopeton from selling, transferring, or providing exclusive possession for the units of car parks that Alarm NZ has leased. Hopeton has obtained building consent to change the use of the building from commercial offices to a 91 residential apartments, with the requirement by the council to undertake a seismic structural strengthening, which then requires access into the building. Hopeton Limited agreed to transfer the car parks 73 and 74 to one of the new residential units to be purchaser, which was actually leased to Alarm New Zealand. Hopeton Limited wrote to Alarm NZ a letter stating that the building cannot be occupied while council notice work needs to be carried out for the seismic structural strengthening. It's misleading Alarm New Zealand to terminate the lease and vacate the building. Alarm NZ claims special damages in temporary relocation costs, loss of business profits, and general damages. The remedy also sought for breaches of lease, including permanent injunction preventing the sale of car parks of 73 to 74 during the term of the lease. Alarm New Zealand also expressed concern about car park 75 and 76 being sold, looking at a apparent of unavailability of any other car park, and bearing in mind of Hopeton's actions to date, an interim order in respect to car park 75 to 76 is granted. So the results mean that this application has been dismissed regards to the car park 73 to 74, and it's been granted for the car parks 75 to 76.